Welcome to the Disability Benefits channel, folks. I'm your host, Emmett Irwin, and today we are talking about pandemic unemployment benefits, which is like unemployment benefits on steroids, and also the interaction with other programs and protections. And I have here with me attorney Jeffrey Sadri, who focuses on labor and employment issues. Good morning, Jeffrey. How are you?
Good morning, Emmett. I'm well. Thank you very much for having me this morning.
Thanks for being here. All right, first I want to talk about the pandemic unemployment assistance, which is like unemployment on steroids, as I said. And this is an extra $600 a week in federal aid, but only for 4 months, only until July 31st, 2020, and that cuts off at that point. So I want to give an example of restaurants which are having a really hard time right now. They are closing in droves. Some of them are only open for delivery or curbside pickup, and they are furloughing or laying off a huge percentage of their workforce. And under this pandemic unemployment, a person who is making, say, $25,000 a year at a restaurant would actually be making over $30,000 annualized salary for the next 4 months if they were laid off or furloughed. And also the restaurant's owners, if the restaurant closes completely and they're self-employed, they could also receive this pandemic unemployment assistance, which is really unheard of in the history of the United States. Self-employed people have never been able to collect unemployment. And there's also different categories of people who had to quit their jobs who may be eligible for this pandemic unemployment assistance. So it's a really incredibly sounding program. But Jeffrey, people should be aware of other programs, shouldn't they? Because unemployment might not be the best thing to claim at this point.
Absolutely, Emmett. The CARES Act does provide for a number of situations which allow individuals to claim unemployment benefits. Some other situations include when an individual has been diagnosed with COVID-19 and is seeking a medical diagnosis. However, a person cannot claim both unemployment benefits and paid sick leave or other paid leave benefits at the same time. Therefore, it's extremely important for individuals to look to the Families First Coronavirus Response Act, which was signed by President Donald Trump on March 18th, 2020. Now, I'll be getting into two major provisions of that act. The first is the Emergency Family and Medical Leave Expansion Act, which I'll just refer to as Emergency FMLA. And the second is the Emergency Paid Sick Leave Act. Now, under the Emergency FMLA, businesses with less than 500 employees are covered under that act. For an employee to be eligible, he or she must have been employed by the company for at least 30 days prior to being able to exercise the FMLA leave. Now, to invoke the emergency FMLA, the employee must be unable to work or telework due to a need for leave to care for a son or daughter if the school or the place of care is closed, or otherwise the child caregiver is unavailable due to the coronavirus pandemic. The emergency FMLA provides 12 weeks of leave and job-related protections. The first 10 days of leave are unpaid. However, an employee can utilize accrued personal leave or other paid leave, such as sick leave that's available under the Emergency Paid Sick Leave Act. The subsequent 10 weeks of leave will be paid, and generally the payment will be at 2/3 of the employee's regular rate of pay. After the individuals finish utilizing the FMLA, the employee will generally need to be restored to the job position that they previously had prior to taking the leave. It is illegal for an employer to discriminate against an employee because that employee has taken leave or has otherwise opposed a practice which is made unlawful under the Act. Now, under the Emergency Paid Sick Leave Act, It similarly covers businesses with less than 500 employees. However, the eligibility requirement is different in that all employees will be eligible for the leave regardless of their duration of employment. As soon as an employee becomes employed, he or she will be able to utilize the emergency paid sick leave. Now, it's 80 hours of paid sick leave, and there are 6 different scenarios which allow an employee to utilize the paid sick leave. The first is when an employee is subjected to a quarantine. The second is when an employee has been advised to self-quarantine. And the third is when the employee is experiencing symptoms which are related to COVID-19 and is seeking a medical diagnosis. For any of those 3, the employee will generally be entitled to pay at the regular rate. Now, there are other scenarios which only give an employee 2/3 of the regular rate, such as an employee caring for another individual, by way of example, someone who's subjected to a quarantine. Now, this next scenario has a direct relationship with the emergency FMLA that I had touched on. If the employee needs to care for a son or daughter whose school or daycare facility is closed, that allows for the emergency paid sick leave and can be utilized as paid leave under the first 10 days of unpaid leave under the emergency FMLA. Now, it's important to note that under the
I'm sorry to interrupt, but that would allow someone who is home caring for a child for a total of how many weeks? 12 weeks of paid sick leave and paid FMLA?
So one way that an employee can utilize both provisions of the statute when it comes to caring for a son or daughter whose, let's say, school is closed, is to utilize 80 hours of paid sick leave under the Emergency Paid Sick Leave Act. So that would be 2 work weeks. And then the subsequent 10 weeks will be paid leave under the Emergency Family and Medical Leave Expansion Act. Now, under that situation, it is important for an employee to give as much notice as is practicable to the employer prior to utilizing that kind of leave. It shall be unlawful for an employer to discriminate against somebody because that person has utilized leave under the Emergency Paid Sick Leave Act or is otherwise opposed to practice made unlawful under the Act. So these 2 provisions I've discussed under the Families First Act are very important for individuals to know because of the job protections and the anti-discrimination provisions that come with them.
That is fantastic information for everyone to have. Now, correct me if I'm wrong, but I had heard quite a few exemptions in your description of the paid sick leave and paid FMLA. For example, companies with 500 or more employees. So there's going to be a large swath of employees who aren't eligible for this kind of for these kind of benefits. So what should those employees look into?
So going to your point about companies with more than 500 employees, an individual can utilize the regular FMLA. And for clarity purposes, the emergency FMLA constitutes an amendment to the already existing FMLA. The FMLA has different eligibility requirements, but allows for 12 weeks of unpaid leave. It has the same anti-discrimination provision, but for an employee to be eligible for leave under the FMLA, generally he or she needs to have been employed for at least a year prior to taking the leave, and the FMLA applies to all businesses with more than 50 employees. One thing that people may want to consider is applying for both unemployment benefits and unpaid FMLA leave, because the FMLA is unpaid. So by way of example, if someone is experiencing a serious health condition that's associated with this pandemic, that can potentially allow the individual to collect funds under the unemployment insurance provisions of the CARES Act, but also acquire job protection under the FMLA.
Now, my theory in this situation, this coronavirus crisis, with all these companies closing their doors or cutting down workforces, especially the companies who are laying off large portions of their workforce. My theory is that most of my clientele, who are older people and disabled people who are actually working now, are going to be at high risk of these layoffs. Traditionally, companies have looked to lay off older people and disabled people first, prior to younger and healthier people. Do those type of people have any other protections if they are not eligible for these kind of benefits?
So generally speaking, under both federal and state law, it's illegal for an employer to discriminate against an employee, which would include discharging an employee due to that person's age or underlying medical condition. It is very unfortunate that the elderly and the medically ill are especially vulnerable at this time frame. So it's important for every termination context to be analyzed to determine whether or not age or disability is in fact being used as an impermissible motive.
Thank you very much for that answer. And at this point, I'd like to give a disclaimer to everyone who's watching this video. This is general information that Jeffrey and I are giving about the new laws. It should not be construed as legal advice. These laws are too complicated and too new and too vague to be analyzed for any particular person at this point through a video. And let me add that nobody should ever take legal advice from a video. If you would like to contact Jeffrey, I am putting his contact information in the text below the video, and I'm also putting my contact information in the text below the video. If you'd like to contact either of us, please do so through that means. Jeffrey, I'd also like to ask, because a lot of older people and disabled people are particularly vulnerable to this coronavirus, many of them might be complaining at their workplace about the conditions. We recently heard about a pork processing plant which shut down because a large percentage of their employees have contacted the coronavirus. If a person is afraid of workplace conditions they are currently involved in, do they have any protections under the law for complaining about those conditions?
Well, rightfully so, many individuals do have a compelling interest to feel safe in the workplace, especially during this time. So under the Occupational Safety and Health Administration's regulations, it is illegal for an employer to discriminate against an individual because that individual has protested against what he or she believes is an unsafe or an unhealthy work environment. And this prohibition extends to all employees, regardless of whether you are over 40 years of age or whether you are suffering from an underlying medical condition. If an individual believes that they are being subjected to an unsafe work environment, they should follow the chain of command and express their concerns in writing to the appropriate upper management or human resources official. Now, it's important to note that each discrimination or wrongful discharge claim will have a different statute of limitations depending on the underlying basis for that discharge. So it's important to consult an attorney to discuss the details of that discharge prior to making a decision.
For our viewers out there who are listening to this video and watching this video about these different kind of benefits and protections, most of these benefits only last through December 31st, 2020, and they might even expire earlier than that. So if you, in the unfortunate event that you cannot get your job back and you have an underlying medical condition that's very severe, you might want to consider applying for Social Security disability insurance. And I'm going to have other videos about Social Security disability insurance, also known as SSDI, in my channel, in the Disability Benefits channel. And so if you'd like to hear about those kind of videos and other informative videos, please subscribe by clicking on the red subscribe button that's somewhere on your screen. Thank you very much for watching, and thank you, Jeffrey, for joining us.
Thank you very much for having me.
Okay, see you next time, folks.